So, good evening, everyone. I hope you people are doing fine. Well, today's topic for the session is right to marry a person of your choice, uh, which was recently recognized as a fundamental right under Article 21 of the Constitution by the Supreme Court in Shafeen Jahan versus Ashokan KM, popularly known as the Hadiya case. A very recent landmark judgment that has come recently. This judgment has recognized this right, right to life and personal liberty, like I've already said in the earlier sessions also, that Article 21 of the Constitution is one of the rights that covers almost everything under the sun, because Supreme Court has time and again interpreted the words life and personal liberty, and has attributed wider connotations and interpretations to these words life and personal liberty. By life, I repeat, the Supreme Court means that it is not animal existence. We cannot confine mere food, shelter, and clothing as the only necessity or part of human beings' life, because we are talking about the life of human beings. And since we are talking about the life of human beings, we have to understand that it's not just limited or merely confined to food, shelter, and clothing. It also goes beyond these basic or bare necessities. So settling down in a society, living as a family is a unit of a society, and living as a family, marrying a person of your choice is also a part of a human being's life and personal liberty. Everybody who is an individual and who is an adult should have this right, should have this liberty to choose a person whom he or she wants to share the rest of his life with. Okay, nobody else has this right to intervene into somebody's very personal affairs, like marriage, and say that no, you are not supposed to do this or you are not supposed to do that, because these are clear violations of there's a comment from Chitralekha Bhagwati. Good evening, Ms. Bhagwati. Thank you so much for recognizing and appreciating my efforts. You should thank RostrumLegal, and I guess all the people who are watching these series should subscribe this channel, should join every evening, whether on LinkedIn or Facebook, or subscribe this channel on the YouTube so that you can also see the recorded sessions. Okay, thank you. So this is I was talking about that fundamental rights. This is one of the biggest, one of the landmark judgments that has recognized this recognize this right to marry a person of your choice as a fundamental right. So this was, it's not that it never existed before, it always existed, but uh, any law needs a time to evolve itself, to grow further, and it happens only when there are circumstances that takes place, like what happened in the case of Hadiya. Now I'll give you a brief introduction regarding the facts of the cases. What were the facts of the cases? And I'm starting to share the screen. See, these are brief facts of the case. The brief facts of the case: Hadiya Jahan. She was originally Akhila Ashokam. Okay, this Ashokan is her father's surname, Ashokan. Uh, Originally Akhila Ashokan, converted to Islam during her medical studies in Coimbatore. She was actually a student of homeopathy in Coimbatore. She then met a Muslim man named Shafeen Jahan and married him at the age of 25 years. So at the age of 25 years, when she got married with Shafeen Jahan, this created the biggest controversy in India. Okay, she was a medical student. She was a student of homeopathy, and her name was Akhila Ashokan. She was a Hindu. Later, when she met a Muslim man and she fell in love with Shafeen Jahan, she married him, and obviously she embraced Islam at the age of 25. So when Akhila's father, Mr. K.M. Ashokan, found out about the marriage, he filed a writ petition in the Kerala High Court. Obviously, the parents of Akhila, or now Hadiya, they were so embarrassed, they felt so embarrassed and so perturbed by the step taken by their daughter, that she fell in love first of all with a Muslim guy. She then married him, and she also embraced Islam. So this was quite disturbing for the parents. So the parents, her father, sorry, Mr. K.M. Ashokan, filed a writ petition before the Kerala High Court. He alleged that Hadiya had been misled and forced to become a Muslim. He also alleged that Akhila's husband had links to extremist Muslim organizations. Hadiya maintained throughout the High Court proceedings that her conversion to Islam as well as marriage to Shafeen Jahan was of her own volition. Now, Akhila's father, Mr. K.M. Ashokan, he was so perturbed, he was so disturbed that he even went to level allegations against Akhila's husband that he had some links with the extremist Muslim organizations, and she was misled, she was manipulated, her mind was brainwashed properly by a Muslim guy, and this is a sort of, like, recently came to be known as love jihad, in the words of our government, because the state of Uttar Pradesh has already passed a law which was recently challenged before the Allahabad High Court, and this is still pending. And Madhya Pradesh government also has also made this law love jihad. I don't know whether it was challenged before the Madhya Pradesh High Court or not, but the judgment of the Allahabad High Court is pending upon the constitutionality of the love jihad law in Uttar Pradesh. So this is a sort of new things which are taking place in our society. So Hadiya maintained throughout the High Court proceedings that her conversion to Islam as well as marriage to Shafeen Jahan was of her own volition. However, on 24th May 2017, High Court Justices Surendra Mohan Kuriakose, I'm sorry, I'm not able to pronounce the South Indian name, and Abraham Matthew annulled the marriage and called it a sham. Surprisingly, this judgment came from the Kerala High Court. There are certain judgments, there's one personal thing that I want to share, that वैसे तो Kerala is a very literate state and is known for its liberal perspectives and modern perspectives, and but I don't know how far. I have come across many judgments of the Kerala High Court which were not at least expected from the Kerala state of Kerala, like what happened in the case of the right to keep silence. That was also a sort of judgment which was highly unbecoming from the state of Kerala itself. I am talking specifically from the state of Kerala. So this surprisingly came as from the High Court of Kerala, that the two judges bench, they annulled the marriage and they called it a sham. Their judgment observed that her that means Hadiya's marriage, being the most important decision in her life, can only be taken only with the active involvement of her parents. See, perhaps the judges of the Kerala High Court, they were, quite possessive. They were quite possessive about their own children. So they said, no, these decisions are supposed to be taken by the parents, not by the person himself or herself. So the justices granted Mr. Ashokan custody over Hadiya and ignored the fact that Hadiya, a legal adult, did not consent to parental custody. See, they called it a sham. They said that no, we are of the view that this decision should not have been taken by Hadiya herself. In fact, this parents should have been completely involved in making the biggest decision of her life. And the Kerala High Court granted Mr. Ashokan custody over Hadiya. They said that no, you have all right, being a father of your daughter, being a father of Hadiya, you have all right to have her custody, and ignored the fact. I don't know how this judgment, on what grounds this judgment was pronounced and it was delivered, because after a person attains the age of majority, which is 18 according to the Indian Majority Act, how can a person be put into somebody's custody? I don't know, even a law student would know this, that this cannot be done. This custody wala thing jo hai, this cannot be, this is not applicable on an adult person. An adult is an adult, and वो major हुआ ही क्यों है? वो इसलिए हुआ है कि that he does not need any custody, he does not need any guardianship now, and he or she has all the liberty to take decisions as like that of marriage. So the justices granted Mr. Ashokan custody over Hadiya and ignored the fact that Hadiya, a legal adult, did not consent to parental custody. She said, no, I never said that I want a parental custody or I want to go into the custody of my parents. I never said this. So how can you put me into into the custody of my parents? I don't want to stay with them. Subsequently, Hadiya's husband approached the Supreme Court to challenge the annulment. Obviously, ये तो होना ही कि केरला हाई कोर्ट के जजमेंट के खिलाफ शफीन जहां जो थे ये चले गए और सुप्रीम कोर्ट उन्होंने अपील करी. On 8th March 2018, the three judge bench of Supreme Court set aside the annulment. This is the date of the judgment. On 9th April 2018, it delivered the judgment, holding that the Kerala High Court could not have used Article 226 to annul the marriage of an adult. Now, the bench was initially headed by Chief Justice. This is not so important paragraph. Just for your little information, it does not matter who was on the bench. What matters is the judgment. The bench was initially headed by Chief Justice Kher, who took the extraordinary step of ordering the NIA, National Investigation Agency, to investigate Hadiya's marriage. CJI Kher retired during the hearing on 27th August. Chief Justice Mishra took over from him. CJI Mishra, perhaps recognizing the problematic nature of the NIA investigation, never called for the NIA to present its report during the hearings. Okay, during the hearings. Furthermore, the NIA investigation finds no mention in the court's judgment. Now, since NIA, why this investigation was ordered? Because the allegation was that Shafeen Jahan had some links with the extremist Muslim organizations, and that it was their objective to manipulate Hindu girls like Akhila and manipulate their minds and convert them into Islam, make them embrace Islam. So this was leveled, and extraordinary step इन्होंने Chief Justice Kher ने ये लिया कि नेशनल इन्वेस्टिगेशन एजेंसी को ऑर्डर कर दिया कि इन्वेस्टिगेट करें. ठीक है. Now, surprisingly, ऐसा हुआ कि Chief Justice Mishra ने, recognizing the problematic nature of the NIA investigation, never called for the NIA to present its report during the hearings. He never said that, no, you have to present the report. Never. Furthermore, the NIA investigation finds no mention in the court's judgment. और उसका फिर क्या हुआ कुछ नहीं पता, क्योंकि कोर्ट के जजमेंट में कहीं पर भी NIA की रिपोर्ट का कोई जिक्र ही नहीं है, क्योंकि CJI मिश्रा ने तो उस रिपोर्ट को बुलवाया ही नहीं कोर्ट में. Summary of the judgment. The High Court wrongly exercised its habeas corpus jurisdiction. Habeas corpus? Habeas corpus is a writ under Article 32 of the Constitution of India. This is a Latin term which means produce the body or to have the body. Okay, the High Court wrongly exercised its habeas corpus jurisdiction. Why this habeas corpus was filed? This habeas corpus was filed. Earlier I said during the facts of the case, I told you that writ petition was filed by Mr. Ashokan KM, father of Akhila or Hadiya Jahan. So he filed a writ petition. Which writ petition? Habeas corpus was filed because he wanted the custody of her daughter, his daughter, क्या नाम है, अखिला अशोकन. ठीक है, अखिला अशोकन जो उनकी बेटी थी उसकी कस्टडी चाहिए थी. लेकिन अब आप ये सोचेंगे कि रिट पिटिशन तो स्टेट के खिलाफ फाइल होता है, क्योंकि आर्टिकल 12 में जो हमने डेफिनेशन पढ़ी हुई थी, आर्टिकल 12 में जो हमने डेफिनेशन पढ़ी थी, वो ये पढ़ी थी कि जितने भी फंडामेंटल राइट्स हैं, दे आर एनफोर्सेबल अगेंस्ट द स्टेट। और जो भी डेफिनेशन में फॉल कर रहा है आर्टिकल 12 की, वही स्टेट होगा। बट शफीन जहां इज अ प्राइवेट इंडिविजुअल। ये अगर हदिया को उसने इलीगली डिटेन कर रखा है, तो हेबियस कॉर्पस कैसे फाइल हो जाएगी उसके खिलाफ? बट यहां पर मैं आपको बता दूं, हेबियस कॉर्पस इज अ रिट which can also be filed against a private individual. Habeas corpus is a writ which can also be filed against a private individual. And same thing happened in the case of Hadiya, that KM Ashokan filed a writ of habeas corpus before the Kerala High Court because he said that the marriage was absolutely void and that he wanted the custody of her daughter. Okay, he wanted the custody of his daughter. So the writ of habeas corpus, when this matter went to the Supreme Court, the Supreme Court said that the High Court has wrongly exercised its habeas corpus jurisdiction. It's not that the writ could not have been filed against a private individual, no, but the case was that the person, that means Hadiya or Akhila, was an adult. She went out of her own consent to Shafeen Jahan, and she got married with him. She embraced Islam out of her own free consent. Now there is no scope left for any exercise of, for the exercise of any habeas corpus writ. So the writ of habeas corpus is a great constitutional privilege. What the Supreme Court said, the writ of habeas corpus is a great constitutional privilege, or the first security of civil liberty. It is a remedy against illegal detention which affects the liberty and freedom of the detainee. Okay, it is a remedy against illegal detention. Somebody who is illegally detaining you and detaining your person, the person of your body, you know, then it is a remedy against illegal detention which affects the liberty and freedom of the detainee. Its purpose is to see that no one is under illegal confinement, deprived of liberty without the sanction of the law. In this case, the High Court misused the habeas corpus. When Hadiya appeared before the High Court, she stated that she was not under illegal confinement. The High Court has no power to decide the just way of life or correct course of living for Hadiya. She has absolutely autonomy over her person. तो यहाँ पर सुप्रीम कोर्ट ने कहा कि ये इलीगल डिटेंशन के खिलाफ रेमेडी है जो किसी भी इंडिविजुअल की लिबर्टी या फ्रीडम को हैम्पर करती है। इसका पर्पस जो है वो ये है कि कोई भी इलीगल कन्फाइनमेंट में ना रहे जहां पर उसकी लिबर्टी को उससे डिप्राइव कर दिया गया है विदाउट द सैंक्शन ऑफ लॉ। और इस केस में हाई कोर्ट ने हेबियस कॉर्पस का उल्लंघन किया है, मिसयूज किया है। ठीक है, हदिया जब हाई कोर्ट के सामने अपीयर हुई थी तो उन्होंने ये कहा था कि वो इलीगल कन्फाइनमेंट में नहीं है। हाई कोर्ट के पास ये पावर, ये इख्तियार नहीं है, ये अथॉरिटी नहीं है कि किसी की पर्सनल लाइफ के बारे में बताए कि तुम्हारे लिए क्या जस्ट है, क्या अनजस्ट है, या सही तरीका क्या है जिंदगी गुजारने का। हर इंसान को हदिया की तरह अपने ऊपर पूरा इख्तियार है कि अपनी जिंदगी के बारे में खुद डिसाइड करे। शी हैज एब्सोल्युटली ऑटोनॉमी ओवर हर पर्सन। Moreover, in Hadiya's case, the High Court was guided by social considerations. See, Kerala High Court did not, completely set aside the constitutional ideals. It never, gave paid heed to while writing the judgment. Perhaps they never consulted the Constitution of India. They never tried to make an effort that at least they could have peeped into the book of Constitution of India and find out that what actually the scene is, the solution is. But they said no, it was guided by social consideration कि एक लड़की है, उसके शादी का डिसीजन उसके माँ बाप ही ले सकते हैं। तो इस टाइप से इन्होंने ये चीजें मतलब सोशल कंसिडरेशन से ज्यादा गाइड हो रहा था केरला हाई कोर्ट in comparison to the constitutional ideals. ideals. Moreover, in Hadiya's case, the High Court was guided by social considerations. It was wrong and unnecessary to go into aspects of social radicalization in a writ of habeas corpus. It is the job of the law enforcement agencies to look into aspects of criminality. Okay? ये गलत था, it was wrong, और ये required भी नहीं था, it was unnecessary to go into aspects of social radicalization in a writ of habeas corpus. At one point of time, you are saying that a writ of habeas corpus has to be filed. Okay, you are filing a writ of habeas corpus, and then you are alleging that this is against social considerations, and you are talking about social radicalizations, that people of a particular community, they are trying to indulge in jihad, they are trying to manipulate the people and girls of the other religion or other religious group, and this is absolutely, these two things have no connection. If you are filing a writ of habeas corpus, your simple allegation would have that my daughter has been illegally confined by this person, that's it. But you are saying that no, this person has manipulated, he has some links with the Muslim extremist organizations, and therefore the writ of habeas corpus has to be filed. The remedy is not matching the problem. At one point of time, you are talking about social radicalization. At the other point of time, in order to correct it, you are filing simply a writ of habeas corpus to get the custody of your adult daughter. This was absolutely, the two things do not match. It is the job of the law enforcement agencies to look into aspects of criminality, and it was never the job of the petitioner. It was never the job of the petitioner that he alleged that he had some links with the Muslim organizations. If he suspected, he could have filed an FIR. He could have resorted to certain other investigating agencies in the state, and he could have said that find out this person I suspect is a man who is linked with certain extremist Muslim organizations which are banned or which are terrorist organizations. Just go and find out. Why did you file a writ of habeas corpus? Okay, so it was the job of the law enforcement agencies to look into the aspects of criminality. The court should only look at whether the person has been detained without lawful authority. See, if the writ of habeas corpus is filed, the only job of the court is to look at whether the person has been detained without lawful authority. That's it. Do not go into the details of how this happened, why this happened, and what are the social considerations, and these are the social radicalizations which are taking place. No. Even if somebody is being taken without his consent and he is being kept under illegal confinement, simply file a writ of habeas corpus. Then don't say that why this happened and how this happened. Okay, it is the job of the law enforcement agencies, I'm repeating this sentence, it is the job of the law enforcement agencies to look into aspects of criminality. The court should only look at whether the person has been detained without lawful authority. Further, the argument that Mr. Jahan would take Ms. Hadiya out of the country was also unnecessary to examine for a habeas corpus case. This actually, the habeas corpus case was not made out because these were simply apprehensions. शक की बुनियाद पर आप कोई रिट पिटिशन नहीं फाइल कर सकते. रिट पिटिशन तभी फाइल होती जब वो चीज सामने हो रही हो. यहां पर एप्रीहेंशंस थे कि वो जो शफीन जहां है वो हदिया को बाहर कंट्री के ले जाए. These were mere apprehensions. Further, the argument that Mr. Jahan would take Miss Hadiya out of the country was also unnecessary to examine for a habeas corpus case. Apprehensions of any future activity, that's what I said, apprehensions of any future activity must be governed and controlled by the state. It is not the job of the petitioner to apprehend the things that this might happen in the future, and therefore I'm filing a writ petition in advance to to prevent this from happening. This cannot happen. These were mere apprehensions. These were mere apprehensions that he is going to do this and he's going to do that. So apprehensions of any future activity must be governed and controlled by the state. It was never the job of the court. Okay. Then, moreover, in Hadiya's case, the High Court was guided by social considerations. Sorry, I was repeating. Yes. Second, thing important was the High Court wrongly invoked the parents' pat right jurisdiction. Now, what is parents' pat right jurisdiction? I think you must, and I believe that you all must have read the judgment of Bhopal gas tragedy. In some MC Mehta case versus Union of India, this doctrine was invoked by the Supreme Court. I may take up this doctrine or these kinds of landmark judgments some other day, but doctrine of parents patriae was invoked. What is a doctrine of parents patriae? Parents patriae is the power of the state to intervene against an abusive or negligent parent or guardian. Okay, if the parent or guardian of any minor is abusive, it may be any guardian, it may be husband. Okay, the state has the right to intervene. The state acts as the parent of such an individual, and this doctrine of parents patriae is not limited to this one sentence that I read. Doctrine of parents patriae means that the state has to act like the parents of its citizens, and it has to ensure basic rights. Like when the Supreme Court invoked this doctrine in the Bhopal gas tragedy case, it said that it was the job of the state to act as parents of the citizens and to ensure that these kinds of negligence and accidents do not take place in the society. And if that happens, even if that happens, despite best of the precautions being taken, you know what has to be done? What has to be done? The state has to compensate the citizens like parents. So, parents patriae also is the power of the state to intervene against an abusive or negligent parent or guardian, and the state acts as the parent of such an individual. And when the state becomes the parent of an individual, the state automatically has to take care almost of everything of that person like a parent. The courts can invoke this role only in exceptional cases where the individual is either mentally incompetent or underage, or has either no parent, legal guardian, or has an abusive one. So Miss Hadiya is neither mentally incapacitated nor vulnerable. इन्होंने ये कहा सुप्रीम कोर्ट ने कि आपने बहुत गलत तरीके से इन्वोक की है पेरेंट्स पेट्राइट डॉक्ट्रिन, क्योंकि यहाँ पर ये तब लगेगी जब या तो बंदा या इंडिविजुअल जो है वो इनकॉम्पिटेंट हो, अंडर एज हो यानी कि माइनर हो, या उसके पेरेंट या उसके लीगल गार्डियंस बहुत एब्यूजिव हों उसके साथ. अब एब्यूज कैसा भी हो सकता है, वर्बल भी हो सकता है, ओरल हो सकता है, मेंटल हो सकता है, फिजिकल हो सकता है, कैसा भी एब्यूजिव हो. मिस हदिया जो हैं, जो अर्लियर अखिला थी, वो ना तो मेंटली इनकैपेसिटेटेड थी ना वो वल्नरेबल थी. She equivocally expressed her choice, and the right to choose is a constitutionally guaranteed freedom and a facet of individual identity. See, this is what the Supreme Court said, and this right was recognized. It was given a status, it was given a face in this case, that the right to choose is a constitutionally guaranteed freedom and a facet of individual identity. It is everybody's right. Once a person becomes an adult, he or she has the right to choose a person whom he or she wants to spend the rest of the life with. Okay, so she equivocally expressed her choice, and the right to choose is a constitutionally guaranteed freedom and a facet of individual identity. It could not take precedence over social and moral values. Your constitutional rights cannot take precedence over social and moral values. We have developed certain customs, mores, and many things. So these customs and these mores, these are, these are important things, but they are not as important as your fundamental rights. They cannot have primacy over your constitutional rights. Even if there is a conflict between any custom, any more, any practice, any usage with any of your fundamental right, it has to go. What does Article 13 says? That law, the word law includes any law, rule, bylaw, notification, custom, or usage. Even if it happens to be an age-old custom which is prevailing in the society, and if it tends to violate any of your fundamental right which is contained in Part 3rd of the Constitution, it has to go. It cannot stay away, cannot stay back. Okay, it cannot stay back. So she equivocally expressed her choice, and the right to choose is a constitutionally guaranteed freedom and a facet of individual identity. It could not take precedence over social and moral values. Could not take precedence over social and moral values. A constitutional court must protect fundamental rights and thus could not reject Hadiya's choice. Okay, a constitutional court must protect fundamental rights. The Supreme Court is telling the job of the Constitutional Court that we are here, we are sitting here to protect your fundamental rights. What is the job of the judiciary? The job of the judiciary is to protect, is to guard your fundamental rights. Okay, so right to marry a person of your own choice came out as a fundamental right under Article 21 of the Constitution. So a constitutional court must protect fundamental rights and thus could not reject Hadiya's choice. Okay. Now, next is the High Court transgressed on constitutional rights. Miss Hadiya and Mr. Shafeen Jahan are adults who decided to marry each other. Okay. Miss Hadiya and Mr. Shafeen Jahan are adults who decided to marry each other. Marital status is conferred through legislation or custom. The High Court was wrong in letting parental love and concern override the right of an adult to choose who she wishes to marry. This is what the Supreme Court said, that the Kerala High Court has transgressed on constitutional rights of Hadiya and Shafeen Jahan. Because Miss Hadiya and Mr. Shafeen Jahan, both of them happens to be the adults, legal adults. They have decided to marry each other. And you cannot also say that Hadiya was manipulated. Her mind was brainwashed. She was an adult. She was not vulnerable. She was not underage. She was not incompetent to understand. She never lacked the sagacity to distinguish between what is right and what is wrong. She never distinguished, she never lacked the sagacity to decipher what is good and what is bad for her. Okay, she's a student of medical science. She's studying homeopathy in Coimbatore. She has been living since, she has been living away from the parents and she's been studying there. So what do you think this girl who happens to be a student of medical science, who studies homeopathy, who is going to become a doctor, do you think she is going to be as vulnerable and incompetent, and she would lack any sagacity to distinguish between right and wrong, between truth and falsehood? Absolutely not. So your marital status, they both got married. Marital status is conferred through legislation or custom. The High Court was wrong in letting parental love and concern override the right of an adult to choose who she wishes to marry. Okay, so यहां पर देखिए पेरेंटल लव और कंसर्न अपनी जगह पर है, और जो कॉन्स्टिट्यूशनल राइट है वो अपनी जगह पर है. अगर दोनों के बीच में कोई कॉन्फ्लिक्ट हो रहा है तो कॉन्स्टिट्यूशनल राइट्स या आपके फंडामेंटल राइट्स शैल बी गिवन प्राइमेसी ओवर सच पेरेंटल लव एंड कंसर्न, बिकॉज in the name of love and in the name of concern, you cannot violate somebody's fundamental right. And if that is allowed, then in that case, perhaps every person, every individual cannot enjoy his or her fundamental rights because somehow they are going to be transgressed on some pretext of some love or concern of somebody else. So this is going to be a disaster for a democracy like ours. We cannot afford to have this. Moreover, the Constitution guarantees that the ability to take such decisions is a part of liberty and individual autonomy. Okay? Is a part of liberty and individual autonomy. Everybody, personal liberty, right to life and personal liberty. So this is a part of liberty. Unless you cannot take a decision of your own, of your own personal life, then liberty किस बात की फिर? आपकी इंडिविजुअल ऑटोनॉमी आपके पास नहीं है तो किस बात की लिबर्टी, किस बात के फंडामेंटल राइट्स? The right to marry a person of one's choice is integral to Article 21. It's integral to Article 21. Choice of a partner lies within the exclusive domain of an individual and is a part of the core zone of privacy which is inviolable. Okay? जो पार्टनर की चॉइस है वो एक्सक्लूसिव डोमेन होता है इंडिविजुअल का. एक्सक्लूसिव किसे कहते हैं? दैट यू हैव अ राइट टू एक्सक्लूड द अदर्स. एक्सक्लूसिव डोमेन है इंडिविजुअल का. When which is something exclusively made for something, exclusively means it is specifically made for this things, all the other things are excluded. It's an exclusive domain of an individual. And this is the prerogative of the individual to decide whom or she or he wants to marry. So choice of a partner lies within the exclusive domain of an individual and is a part of the core zone of privacy. This is a part of core zone of privacy. Like I said, that the judgment on privacy was earlier pronounced by the Supreme Court. Before this it was pronounced. Okay. In Justice Case Puttaswamy versus Union of India, the 9 judges bench already recognized right to privacy. If somebody is making a choice regarding his marriage, his or her marriage, that is completely his private act, his private decision, and that is completely his or her prerogative. So if somebody, even the parents, if they are intervening in these matters like they are trying to manipulate and they are trying to take a decision for somebody else's life, be ये ना हो सकता है वो आपका बेटा या बेटी ही हो, लेकिन इस केस में आप प्रिवेसी का भी उल्लंघन कर रहे हैं और राइट टू मैरी अ पर्सन ऑफ योर ओन चॉइस का, उसकी इंडिविजुअल लिबर्टी का, उसकी इंडिविजुअल ऑटोनॉमी का भी उल्लंघन कर रहे हैं. ओके, कोर जोन ऑफ प्रिवेसी है ये. दिस इज अ कोर जोन ऑफ प्रिवेसी. Thus the High Court was wrong. The High Court was wrong in using its powers under Article 26 to annul Hadiya's marriage with Shafeen Jahan. Okay, तो हाई कोर्ट यहाँ पर गलत था कि शफीन जहां के केस में उन्होंने कहा कि आपने आर्टिकल 226 कैसे लगाया. अच्छा, आर्टिकल 226 यहाँ पर क्या है? 226 में और आप 32 में, दोनों में आप रिट फाइल करते हैं. तो दो बेसिक डिफरेंस क्या है दोनों में? आर्टिकल 32 में आप सुप्रीम कोर्ट में डायरेक्ट जा सकते हैं, वहां पर रिट पिटीशन फाइल कर सकते हैं. आप रिट पिटीशन फाइल कर सकते हैं 32 में, लेकिन वो सिर्फ और सिर्फ सुप्रीम कोर्ट में होती है, पहली बात. और दूसरी बात, वो सिर्फ और सिर्फ फंडामेंटल राइट्स के वायलेशन के केस में होती है. ओके, फंडामेंटल राइट्स के वायलेशन के केस में होती है, किसी भी लीगल राइट के वायलेशन के केस में नहीं होती. दूसरी तरफ अगर आप 226 में जाएंगे तो 226 में 226 में जो रिट पिटीशन फाइल होती है वो हाई कोर्ट के सामने फाइल होती है. ओके, वो हाई कोर्ट के सामने फाइल होती है और वहां पर आप फंडामेंटल राइट्स के साथ साथ लीगल राइट्स के वायलेशन के खिलाफ भी रिट पिटीशन फाइल कर सकते हैं. That means the jurisdiction and powers of a high court under Article 226 are wider than the power of the Supreme Court under 32, because the High Court has the power to, accept the writ petitions on the violations of fundamental rights as well as the legal rights, other legal rights. But Supreme Court only has the power to accept the writ petitions only and only upon the violations of fundamental rights under Article 32. Now, what will happen? What if in this case यहाँ पे 226 लगाया गया, यहाँ पर हेबियस कॉर्पस फाइल की गई केरला हाई कोर्ट में, तो केरला हाई कोर्ट में जो हेबियस कॉर्पस फाइल की गई है उसमें 226 का इन्वोक करना क्या ठीक था? बिल्कुल ठीक नहीं था। ये शुरू में ही आपको बता दिया गया कि बिल्कुल ठीक नहीं था। हेबियस कॉर्पस इलीगल कन्फाइनमेंट के केस में फाइल की जाती, और उसके बावजूद भी, फाइल करने के बावजूद भी, हदिया ने आके सब कोर्ट में कह दिया था, केरला हाई कोर्ट में आके सामने ये बात बताई थी कि ऐसा है कि मैं इलीगल कन्फाइनमेंट पे नहीं हूं। उसके बाद भी केरला हाई कोर्ट ने नहीं माना उसकी बात को, और ये कहा कि ये इलीगल कन्फाइनमेंट ही माना जाएगा, और रिट ऑफ हेबियस कॉर्पस लगा के कस्टडी एक लीगल एडल्ट डॉटर की उसके पेरेंट्स को दे दी। So the High Court was wrong in using its powers under Article 226 to annul Hadiya's marriage with Shafeen Jahan. Okay, so अच्छा 226 में अगर आप रिट पिटिशन फाइल कर रहे हैं किसी भी लीगल राइट के वायलेशन के लिए, देन आप उसके खिलाफ अगर आपको अपील करना है तो आप किस आर्टिकल में आएंगे? देखिए 132, 133, 134 एंड 136, ये वाले जो प्रोविजंस हैं इसमें सब दिया हुआ है। अपील इन सिविल केसेस, अपील इन क्रिमिनल मैटर्स, अपील इन कॉन्स्टिट्यूशनल मैटर्स एंड अ स्पेशल लीव पिटिशन। अगर आप वैसे भी नहीं चाह रहे हैं तो आप एसएलपी सीधा सीधा फाइल कर सकते हैं। मोस्टली अब सारी अपील्स जो फाइल होती हैं वो 136 में ही फाइल होती हैं। यहां पर आप ये नहीं कह सकते कि 226 में, अगर आपके 226 में फाइल की गई रिट पिटिशन हाई कोर्ट के सामने से अगर आप अग्रीव्ड हैं तो उसकी जो रिट पिटिशन की अपील है वो 32 में जाएगी। नहीं, 32 में नहीं जाएगी। आप 136 में जा सकते हैं, आप 134 में जा सकते हैं, अपील इन कॉन्स्टिट्यूशनल मैटर्स में जा सकते हैं। तो इस बात का ख्याल रखें कि 226 से 32 में नहीं जाती है अपील। अपील जाती है एसएलपी के जरिए से मोस्टली। अब 136 में स्पेशल लीव पिटिशन जाती हैं, जहां पर ये प्रूफ करना होता है पिटिशनर को कि there has to be a question of law, and that substantive question of law involved in the case, and that substantive question of law is of public importance, needs to be decided by the Supreme Court. यहाँ पर भी right to marry, individual autonomy, individual liberty और privacy का बहुत बड़ा issue था, जो substantive question of law था, which was of public importance and which was supposedly to be decided by the Supreme Court. So the matter was admitted, and hence the Supreme Court pronounced this judgment. Now I request you to, ask me the questions if you have any doubt. I'm willing to take up the questions. Please ask. Could you explain about these Love Jihad acts, bills by the states? Okay. See, Love Jihad acts or bills by the state, ये जो एक पॉलिटिकल आर्टिफिस है, इट्स अ पॉलिटिकल स्टंट। अभी जो स्टेट ऑफ यूपी में हुआ, ये okay, there are so many questions now, so let me answer them one by one. I'm giving this answer of Ms. Chitralekha Bhagwati. So Love Jihad acts and bills by the states, these are a political stunts. The state of Uttar Pradesh, see, the state of Uttar Pradesh right now has made this law, Love Jihad, against Love Jihad, and it says that it is a punishable offense. If some Muslim boy marries a Hindu girl, this is going to be considered a love jihad, and hence it is going to be punishable. Soon after this was passed by the UP government, this was made by the UP government, this was challenged before the Allahabad High Court upon the constitutionality, because it goes absolutely against this Hadiya judgment of the Supreme Court, and also it goes against the constitutional ideals and constitutional rights. So this cannot stay. Expected is that the Allahabad High Court would definitely strike this down as unconstitutional. MP also has made this law. These are all political stunts, like to divide the society on religious lines, like what is happening in India. We all can see that. Okay. Can you please citation of this judgment? Yes, citation is there on the indianqanun.com. I'll explain. I'll tell you. It is available there. Okay, it is available there on the internet. Let me see. So I'm providing you the citation. Just hold for a while. By the time I'm answering the other questions, if hypothetically we assume that the boy had certain terrorist connections, would then the marriage be considered void, even though the girl is of sound mind and nature? Absolutely not. See, that is what I was trying to explain you. That exactly what I was trying to explain you. That see, आप एक तरफ मैरिज को कह रहे हैं void है, दूसरी तरफ आप ये कह रहे हैं वो इसलिए void है क्योंकि ये जो शफीन जहां इसके कुछ जिहादी कनेक्शंस हैं, टेररिस्ट कनेक्शंस हैं, तो क्या उसका टेररिस्ट कनेक्शन होना इस मैरिज को void कर देगा? नहीं करेगा. वो इशू अलग है और ये इशू अलग है. यही बात तो सुप्रीम कोर्ट ने कही कि ऐसे सिचुएशन पे आप हेवियस्ट कॉर्पस फाइल कर रहे हैं और एलिगेशन आप ये लगा रहे हैं, आपके कंटेंशंस ये हैं. ओके, तो आपके जो कंटेंशंस हैं वो यहां पर एक्सेप्ट नहीं हो सकते. ओके, वो यहां पर एक्सेप्ट इसलिए नहीं हो सकते क्योंकि वो अगर उसके टेररिस्ट कनेक्शंस हैं भी तो दे cannot make this marriage void. Okay, they cannot make this marriage void. उससे नहीं होगा. Girl is of sound mind and nature. क्या अगर टेररिस्ट भी शादी करता तो क्या वो मैरिज void हो जाती? ये देखिए, जो लड़की है यहाँ पे साउंड माइंड की है, मेजर है, she is sane enough to take her own decisions and understand what is good and what is bad. सो मैरिज वॉइड नहीं होती. वो भले ही बाद में उसको डाइवोर्स दे देती, कुछ भी करती, बट मैरिज यहां पर वॉइड नहीं हो सकती थी. ओके मिस्टर सुनील, दिस इज Thrishta Sunil. Okay, so Thrishta, are you have you understood what I have answered? In this judgment, parental love was given over importance. What do you think will be state's object role? See, in the Kerala High Court's judgment, not the Supreme Court's judgment, parental love was given importance by the Kerala High Court, not the Supreme Court. Supreme Court said it is not appropriate to give primacy to parental love and concern over your fundamental rights. Okay, so what do you think will be the state's object or role? State's object or role is nothing here. State has to consider the marriage as valid because it is the state that has to make sure that किसी का fundamental right violate ना हो. Okay, तो किसी का fundamental right यहाँ पर violate ना हो, तो ये जो है, this is like the responsibility or object of the state. Okay. See, I am posting a comment here. So somebody was asking about the citation of the judgment. This is the citation of the judgment, SCC Online, Supreme Court 343 2018. Sir, I meant what would be state's interest in passing such biased laws that go against fundamental rights. स्टेट का इंटरेस्ट ये है कि देखिए, ये सब पॉलिटिकल स्टंट होते हैं। एक रिलीजियस लाइंस के ऊपर कम्युनिटी को डिवाइड करना, एक मेजर वोट बैंक को सिक्योर करना, फीलिंग ऑफ कम्युनलिज्म, फीलिंग ऑफ रिलीजियस हेट्रेड टुवर्ड्स द अदर कम्युनिटी, इसको इग्नाइट करना, ये पॉलिटिशियंस का बहुत पुराना काम है। ठीक है। और इससे क्या होता है, हर वो चीज अगर वो देखते हैं कि चलिए अगर मुसलमान लड़का और हिंदू लड़की शादी कर रहे हैं तो इसको लव जिहाद बोल दो, और इससे क्या है, डिवाइड क्रिएट करो एक, जिससे ज्यादा से ज्यादा इमोशनल रिलीजियस जो रिलीजियस इमोशंस होते हैं इंसान के, उनको एक्सप्लॉइट करो और वोट वोट लो, ताकि लगे लोगों को कि हाँ हमारे रिलीजन का रखवाला कोई आया है पावर में और इसको वापस से वोट देना है। ये जो एक मेंटालिटी होती है टू यू नो, देखिए पढ़े लिखे लोग जो हैं या जो भी अच्छे इंटेलेक्चुअल्स हैं वो इन बातों को हीट नहीं देते हैं, बट जो रूरल एरियाज में बहुत सारे लोग रह रहे हैं, बहुत सारे लोग जो हैं वो इन चीजों को बड़ा वैल्यू करते हैं कि नहीं हमारे रिलीजन को कुछ नहीं होना चाहिए, भले ही डेवलपमेंट हो या ना हो। तो इस वजह से जो स्टेट का मकसद होता है वो ये होता है कि बायस लॉस पास करो, भले ही वो कोर्ट्स जो हैं उसको अनकॉन्स्टिट्यूशनल डिक्लेयर कर दें बाद में, बट बायस लॉस से क्या होता है, एक मेजर वोट बैंक सिक्योर होता है। ये इंटरेस्ट होता है स्टेट का टू कम बैक टू द, और ये स्टेट का इंटरेस्ट नहीं है, एक्चुअली वन पॉलिटिकल पार्टी का होता है। इसको स्टेट का इंटरेस्ट नहीं कहना चाहिए, इसको पॉलिटिकल पार्टी का इंटरेस्ट कहना चाहिए। पॉलिटिकल पार्टी दैट कम्स टू पावर डज दिस। ओके। So I hope questions are over. Should I go offline now? Does that mean that even the judiciary politicizes on matters? Not exactly. How can you say that judiciary politicizes on matters? On what grounds? Judiciary has protected fundamental rights so far. अभी तक लोगों के मौलिक अधिकारों को बचाया है जुडिशरी ने। जुडिशरी ने कभी पॉलिटिक्स नहीं खेली है। जुडिशरी नेवर पॉलिटिसाइजेस अ मैटर, नेवर। ठीक है। तो जुडिशरी का जो अपना है काम है वो फंडामेंटल राइट्स को बचाना है। अब देखिए इलाहाबाद हाई कोर्ट जो जजमेंट देगा इनके ऊपर, इन लॉस के ऊपर, जो यूपी का लॉ है, उससे आपको पता चल जाएगा कि अब जुडिशरी का रोल क्या है हमारी प्रेजेंट डेमोक्रेसी में। So I hope the questions are over now. The number of attendees are dropping. So it's time to go offline. So all the best. Good evening, all of you. Bye bye.